Getting up in the morning, hey, it can sometimes be a hassle. Well, you know what? That takes us to this week's case. It involved a man in New York. He worked for the New York City Social Service Agency, and he unfortunately was schizophrenic and was taking drugs for his schizophrenia. Well, the drugs made him very drowsy and groggy in the morning. Had a lot of trouble getting up and getting going. And he many times would not get into work until almost noon. It was after 11 o'clock in the morning. Well, guess what happened? His employer cited him for tardiness. Cited him for being tardy 30 times. And then engaged in disciplinary action that consisted of him being fired. Well, he argued, wait a second, you know, here we have the Americans with Disabilities Act. I have a disability, it's schizophrenia. I'm taking medication for it. The medication doesn't allow me to get going in the morning, and you are not making accommodations for that disability. On the other side, the city argued, well, wait a second. What accommodations can we make? You have got to be at your job in order to perform your job. And a failure to show up at the specified time is going to indicate that you are not at your job, you're not doing your job, therefore, hey, we can't make accommodations. Well, this case went to a U.S. District Court. U.S. District Court actually entered summary judgment, which is basically deciding the case upon pleadings that were presented to it, motions that were presented to it, finding that, in fact, the man did not have a case. Well, the guy appealed through his attorneys, went up on appeal, Second Circuit Court of Appeals. There, the court looked at this and they said, you know what? There's nothing in the record, there's nothing in the facts that indicate that he has got to be at his job at a specified time in order to complete his job. There's nothing here. And since there's nothing in the facts that demonstrate that, we're going to send the case back down, and a jury will get to hear this and determine whether or not there was sufficient evidence that he needed to be at his job at a certain time. Okay. Well, that was the determination made on appeal. And what does that really mean? Now, this may sound a little absurd, but what we really saw happen in this case is the city of New York did not do a very good job in the underlying action when it was at a motion stage and developing the facts. Because on appeal, what they said, on the present record, we do not find sufficient facts to show that someone must arrive at their job at a specified time. Well, what that means is that the city of New York did not come forward with sufficient evidence, either in the form of affidavits or other form of evidence, job description or whatever else, showing that in order to perform the job, this particular guy needed to be there at a particular time. So the case is going back down. A jury will have an opportunity to hear it. And what do we learn from this? Well, we learn something that I think many people have been aware of for a long time. And sometimes it seems like we get these absurd results in a case. Well, many times it's simply because the person on one side or the other did not properly develop the facts, and that the court was left having to make a decision that it may or may not want it to make because the parties did not properly develop the facts, didn't show the court all of the evidence necessary to make a fully informed decision. And in this instance, the appellate court said, okay, you got to send it back down again, and it's got to be heard again. All right, we bring you this case like we bring you cases every week so you understand how the law works. I'm David Allen.